Okay, it says we're live. Let's do this. It is Tuesday morning, and it's just me. Cameron had to get going for work, but and y'all, I had a pretty late night, so here we are. Up and at 'em. I want to talk this morning about. Okay, so last night, we did the live stream to celebrate the confirmation and actual swearing in. We actually streamed and got to watch a little bit of the swearing in ceremony of Amy Coney Barrett, and thank God for that. As I've said before, but for several reasons, she's not. I'm not super excited about any of the justices that Trump has put on. I've been disappointed by both of the men that were put on prior to Amy. I think I'm a little more salient, a little bit happier with the Amy choice. I mean, she's got 7 kids, so she's clearly got more steel in her spine than either of those squishes, Kavanaugh or Gorsuch. But just, we're glad to have her. And we had the question last night, isn't the Supreme Court supposed to balance out the, oh, there's Drew, it was your question, to balance the liberal and conservative, and we went into pretty solid detail on that. This morning I want to talk about, and this relates to the, okay. Sorry about that. The wife is asking me to let her know when we're done with the show so she can have one of the kids vacuum, and that's good. So anyway, it's never the job of the court to balance politics, liberal versus conservative. The job of the court is only ever to interpret the law. We went into great detail on that last night, like I said, and everyone should be thrilled when the conservative takes a majority over the left on the Supreme Court, precisely because by the very dint of being a leftist, the left-leaning judges on the court should be impeached because they serve in active, constant, abrupt violation of their oath of office, which includes and is primarily to uphold and defend the Constitution of the United States of America. And we've seen in the past the clearest example of this obvious violation of the oath. They cannot hold the oath in good faith, is Heller versus D.C., where while the Constitution won mostly in that case, the opinion of the left was not that there are reasonable restrictions that can be placed on gun ownership, right? The argument that was made by the left-leaning justices in that case was very clear. Their position is there is no right for an individual to keep and bear arms. You don't get to have a gun. Not for any purpose whatsoever. You can't have a sporting rifle. You have no right to self-defense. Their position was that the Second Amendment was there merely to authorize the military to hold arms. And that's absurd. That's... okay. Alex says you could argue the exact same thing about the right-leaning judges. The only difference is your perception of their ideology. Alex, I challenge you to take my claim based on the Heller decision, and I know it's only a narrow case, it's one case, and support that claim against what I've just detailed. My argument is that a conservative constitutional constructionist is what a judge should be. And other than that is someone who actively seeks to change the Constitution. Someone who actively seeks, as we saw with Ginsburg, as we see with Sotomayor, to change the Constitution, or one that takes explicit actions to change unconstitutional laws in order to fit them into the Constitution rather than send them back to the legislature to be recrafted, as we saw with Roberts and Obamacare and in other cases. Those justices are incapable of holding the oath in good faith. And I would challenge I would also challenge that in those cases, okay, I'll come. Alex, I'm going to give you a little more attention than I should, and then I'm going to move on to, I'm going to be talking about qualified immunity, and I'm glad you're here to argue against me on this, because I know you and I aren't quite lined up on qualified immunity. And Steve, too. That's awesome. So Alex says, that's simple. Each individual judge will interpret the Second Amendment differently. That's because there's no black or white in the Second Amendment. The Second Amendment is very black or white. Thou shalt not infringe. Antonin Scalia was wrong. He was wrong in his correct assenting on the Heller case. He conceded that there is a reasonable restriction to things. The example he used was sawed-off shotguns and a few other types of weapons that are more commonly, at least stereotypically, expected to be used by criminals. That's incorrect. That's not even and in that case, we're talking about Scalia, who was a brilliant legal mind and was a pretty strict constructionalist. And he would use the word textualist, which he kept distinct from the word constructionist by arguing that what he meant in being a textualist is words are written and words have meaning. Well, when he decided, when he argued, even in agreeing with the position that the American citizen has the right to keep and bear arms, he argued a position that was not reflected by the text, because the text says, shall not be infringed. And people think of the word infringed and they think, taking away your rights, or you've got to at least have the nominal right to keep and bear. No. To infringe, you see that the bottom of that shirt? That's fringing, right? That's fringe. That's the edges of a thing. That is, you will not put restrictions around. You will not place concepts near anything, any law. This includes licensure, background checks, waiting periods, restrictions on type. Any law which is somewhat adjacent to the concept of your right to keep and bear arms is patently unconstitutional. There is no argument against that position. That is what the text says, and it does say it clearly. And, okay, to your black and white, it's in black on brown because it was written on that wonderful lambskin. But that is very black and white. That sentence, shall not be infringed, is very black and white. So, Steve says, it's this simple. The militia is made up of the people. The people shall not be limited in their arms. That's simple. That's correct. And one of the favorite arguments of the left. Okay, this video is not supposed to be about Second Amendment arguments. I'm going to get into some stuff about about ballots and about qualified immunity in just a second. And I've got some clips that I want to share with you. But what Steve points out there, let's not forget the Dick Act establishing the definitions and identities of these several militias, which include the militaries, and it breaks the militia overall down into two primary categories, the first being the organized militia and the second being the unorganized militia, both of which are considered by the Dick Act and were established to be considered by the founders as, which is separate. The founders didn't write the Dick Act. It's a little more recent than that by 100 or so years. But it establishes the distinction between the professional military, the active duty, reserve, and National Guard, and what is called the unorganized militia, which is every other able-bodied man between the ages. I think in the Dick Act it's between 15 and 50. I would go so far as to say every able-bodied man, because let me tell you something. I've been in wars and I've seen 5-year-old children throwing hand grenades at soldiers. And that's reality. That's just something that's how it works. And yeah, I know, Alex, your position on qualified immunity is there shouldn't be any, and I'm going to talk about that position as well. You're in, I mean, you're in good company there with BLM and Justice Sotomayor on the abolition of qualified immunity, and so let's dig into that a little bit. And the reason I want to dig into it specifically is here's a sample ballot from Georgia. There is a you yourself just put a qualified definition on the yes I did. The militia is everyone, and the expectation is that every man between 15 and 50 will be armed and will keep his weapons regularly. The Constitution and the Second Amendment says the people. It does not distinguish men and women. Freedom-loving patriots. Yes, Alex. The BLM and Sotomayor are precisely what I think when I think freedom-loving patriots. So let me see how far I can zoom into this, and hopefully you can read it. On the sample ballot, qualified immunity is a subset of sovereign immunity, and we have the state waives state and local sovereign immunity for violation of state laws, state and federal constitutions. So, I am not a perfect expert on qualified and sovereign immunity. I'm not a lawyer per se. I've done some law work, but I don't sit the bar and the like. But my first problem with this entry on the ballot is this. I have a single sentence here. Waives state and local sovereign immunity for violation of state laws, state and federal constitutions. I would be shocked if more than, say, 80% of the people who vote on this question even know what sovereign immunity is, let alone the more refined concept of qualified immunity. And I'm all for qualified immunity, precisely because of that word, qualified. Now, there may be some room to adjust what defines the qualification, but qualified immunity. Because the abolition of qualified immunity means that Trayvon Martin's parents get to sue George Zimmerman, and the police officers, and the court. The absence of qualified immunity, the revocation of qualified immunity, means that Breonna Taylor's parents get to sue the state. Okay? It means that if you're a drug dealer and you shoot at a police officer, then your mama gets rich off the state. That's what it means to abolish qualified immunity. No qualified immunity, Rayshard Brooks gets to sue the state. That's right. The inebriated, child-abusing, sexual predator who fired a weapon at police officers in a state of inebriation gets to sue the state and get rich. That's what the abolition of qualified immunity means. Now, in this sentence, I'm going to have to ignore you for a minute, Alex, so I can keep trucking, so I can actually get through what I'm trying to describe here. This single sentence, waives state and local sovereign immunity for violation of state laws, state and federal constitutions. A large number of people do not even know what they're voting on here. It seems like a simple sentence. And if you know what all of the phrases in there mean, it is a relatively simple sentence. But you're expecting a lot of people to know a lot of information. This didn't even pop on my radar until I hit the ballot, which means it wasn't discussed publicly. because I mean, for something to make it to the ballot without me putting eyes on it is surprising, and that also means this is an act to amend the Constitution of the state, right? Where was the public debate? Where was the conversation? And what else is in the resolution? House Resolution 1023. What else is in there? Take a moment, look back at the stimulus bills that have been such a hot topic and people have been arguing about. You walk around and ask 1,000 people on the street if they want to pass. You walk around and ask 1,000 people on the streets if they want to pass a law that puts $1,200 in everybody's pocket because the government shut down and everybody's broke and everybody's hurting, and you'll find that a large number of those people will say, yes, I want to do that. But what else is in that bill? What else is in that document? What else does it call for? Oh, it calls for a government agency to be created which gets to oversee the composition of private businesses and whether or not their board has the correct mix of ethnicities and sexual preferences. What the hell does that have to do with a stimulus check? It's completely unrelated. Oh, it calls for the airlines eliminating carbon emissions in completely 100% clean, no carbon emissions in 50 years. Yeah, that'd be nice. But that's a thing that happens by innovation and by creation. If you try to put a government mandate on that, you can be certain that it will not occur. Give us Amtrak. We only need it for 50 years. As soon as it's profitable, we'll turn it back over. That was 100 years ago. Shut up. Okay, I'll get to you in just a second, Alex. I note your objections, and they're wrong. That's why the language qualified immunity is so important. But this is on here to adjust the Constitution, and basically nobody knows what's going on with it. I will always vote no to change a law if the actors changing the law make no attempt to argue their case. And especially if there's any chance that that law is untransparent and contains hidden garbage like the stimulus bill does. The other one's on here. Establishes a tax exemption for certain real property owned by charities. I'm sure that sounds very reasonable and very kind. Will those real property owned by charities, will that extend to organizations like the Clinton Foundation, for example? I mean, this is state, so not the Clinton Foundation per se, but I'm sure there are no corrupt charity organizations that would be served by an amendment to the Georgia bill to help charities. I'm not a big fan of charity to begin with, but that's another issue. So WAPO has this video out where they explain qualified immunity, and I had considered we'd go through it and watch it, but I want to show you a couple of tricks that they pull. They make the argument that, here it is. I'm going to play a little bit of this for you real quick.
But they're still granting qualified immunity. From 2005 to 2007, we were looking at cases where defense raises a qualified immunity defense. And in those cases, there was a qualified immunity ruling that favored the police in only 44% of cases. But in the more recent years, from 2017 to 2019, the ruling on qualified immunity favored police 57%, more than half the time. And
here's the con job. She just said that from period A to period B, there were 44% of cases favored police, and period B to period C, 57% of cases favored the police, as if she's showing a trend in an increase in the number of cases that favored the police. But you'll find that over that same period of time, there were also fewer police interactions. Crime was on the downtick. Still is crime crime was still on the downtick even this year, up to and against all reason, including during the riots. And actually, it seems like what's happening during the riots is actual crime rates are lower than historically, while the riots are ongoing. It's just that the fewer crimes that are happening are much more public and visible and, frankly, destructive. Steve says my mic isn't picking up very well. I don't know what the hell's happening there. Let's crank that up. How's that, Steve? That should be better, I think. Okay, and yeah, I'm just gonna have to go through and tear the whole broadcast system apart. I don't know where the mic has gotten weak. Maybe I just need to replace this thing. It's old. So, the argument for qualified immunity, Alex points out here. I typically no one should have immunity for violating someone's constitutional rights. You're right, Alex, and they don't. If you're protected from blatant violations, okay, that's Steve. Civil litigation isn't paid for by the taxpayers and never will be. And what we're talking about here is civil litigation. The litigant still has to have a case in order to I'll say bring, I think is something like that. And frivolous cases won't go anywhere. They'll cost the litigant money, not the taxpayer. That's, okay, Alex, you're making the argument for qualified immunity. That's what qualified immunity is for. That there have been cases where the use of qualified immunity was abused is a different matter. That murder is illegal and people still commit murder does not mean that we abolish the laws against murder. I can make a case for abolishing the laws against murder, but that's not the point. So, the existence of okay, so Alex says, so what you're saying is you want certain branches of government to be able to violate your rights, but you don't think the Supreme Court should be able to violate your rights. See, now you're making that's a straw man. No, what I'm saying is that we should not tolerate frivolous lawsuits against the government. The abolition of qualified immunity is the explicit outcome is that your frivolous lawsuit will not be thrown out. Qualified immunity is the defense against frivolous lawsuits. That's the whole point here. Because when you look at Philadelphia, where at least 12 cops were hospitalized as violent clashes break out over Walter Wallace shooting, okay, the people that are arguing for qualified immunity are rioting and hurting cops over somebody who the cops shot. And do these cops have qualified immunity? No, they don't have qualified immunity. And there is speculation in this state, in this following description, because an investigation has not yet been conducted and a finding has not yet been made. But on the evidence available from the situation, we can make some reasonable speculations. The following is a reasonable speculation. A man wielding a knife attacked several people. They called the police. He attacked the police. Police said the incident started with a call about a man with a knife. Responding officers witnessed a man on the block. Immediately, they noticed he had a knife in his possession, and he was brandishing it and waving it erratically. Police Sergeant Eric Grip told KYW. So, your argument to abolish qualified immunity is that this man and this man's family should be allowed to sue the government and to move forward and successfully take a bunch of money from them. You made the point up here a minute ago, Alex, that that I think you used Rayshard as the example, but you said that the bad guy's mama can try to get rich off the state. Well, no. The thing that prevents her from getting rich off the state when she tries is that the court can say the officer was doing his job here, and when a crazed man with a knife attacked him, he shot that man dead, and so he did not violate that man's civil rights. Qualified immunity, in order to be applied, requires that there be a violation of your civil rights or your constitutional rights. And there's the second part of that. The second part of the qualification and qualified immunity is that it has to be well established. That we can have a deeper conversation on. Certainly, a reasonable judge can look at a case that doesn't have precedent and make determinations in it. Now, that's tricky. That's tricky. But, okay, so most people would call that, Alex, you said most people would call that hypocrisy. I just call it plain wrong. You're going to have to go back and remind me on what point you think I'm a hypocrite. I'd be happy to rebut you on that. So what you're saying is you want certain branches of government, I just covered that, and you think liberal judges should be impeached for misinterpreting the Constitution. So dirty cops should be protected, dirty judges shouldn't. Wow. No, that's Alex, you're better than that. You're better than to erect such a straw man. Or rather a pair of straw men. My point was not that liberal judges should be impeached for misinterpreting the Constitution. They have not misinterpreted the Constitution. My example of the Heller case, they did not misinterpret the Constitution. They made a determination that it said something other than it did. Same thing with the Roe v. Wade case. Most people believe that Roe v. Wade says that it should be lawful, that you have a right to abortion. Roe v. Wade does not say that you have a right to abortion. Roe v. Wade says that from the unenumerated and nebulous penumbra of individual rights, we can suppose that there is a right to privacy enjoyed between a person and their physician, and that if those two people together decide to murder the unborn infant, then they don't have to admit it because the activity was conducted in private. The reasoning, the legal reasoning, and the argument that is made by the judges in Roe v. Wade is that if I call my physician and he comes over here and we chop somebody up in the basement together, that we don't have to tell anybody, and that's okay because of our right to privacy. So no, I'm not talking about a judge misinterpreting the Constitution. I'm talking about activist judges litigating from the bench. And those violations happen every day, and they're protected. Police, municipalities, agencies, all protected. You're wrong, brother. What you're arguing, Alex, is that qualified immunity allows officers to commit civil rights violations. It does not. You can bring qualified immunity does not prevent you from bringing the civil case. Qualified immunity is the basis on which the case can be determined to be frivolous and then thrown out. So your argument earlier that Rayshard's mama can go and try to get rich off the state if there's no qualified immunity. No. If she goes to try and get rich off the state, qualified immunity is the bar of proof that prevents her from making the frivolous claim, from going forward with the frivolous claim. I think what we have here is not that you don't understand the law, you misunderstand the locus of the frivolity. Now, let me show you what, because I used this example from just the other day, because you're going to have he just had a knife. Joe Biden would tell you, well, shoot him in the leg. Let's talk about that. Let's talk about the guy that just had a knife. Here's one. This guy just has a knife. I'm even going to make
Put your hands up.
So see what's happening.
You still got that knife?
Yep.
Put the knife down. Drop the knife. Drop it.
I'm gonna get shut down over this one. Check it out. One stab.
No. Get up there.
One stab. One stab.
Drop it.
So, And Alex, I know you understand the danger of the knife, but that's I wanted to highlight that one because we're talking about cases here where an armed man, a dangerous criminal, or someone who overdosed on drugs while in custody, you're arguing that the death of these men should be the responsibility of the police. These are not extreme cases. These are precisely the cases for which qualified immunity is there to protect an officer so that he can do his job, so that he can take discretionary actions in the line of his job. So that when a criminal assaults him with a weapon, when a man draws a gun or a knife on him or steals his taser and fires it at him, he can do what he needs to do to defend himself. So sure, Alex, let's get rid of qualified immunity. Let's just go ahead and open it up. Let everybody sue a cop over everything that they ever want to, and watch how fast all your police officers start just making silly mistakes because they start to second guess themselves and ask themselves the question is, can I get sued over this? Because without qualified immunity in place, the answer to the question, can I get sued for defending my life in the line of duty, is always yes. And the outcome of that lawsuit is that there is not a mechanism to determine that the lawsuit is frivolous and protect the officer so that he can make discretionary choices. Now, to clear up a little bit, this got a little deeper into qualified immunity because I'm arguing with my buddies in the comments a bit. The thing that's on the ballot in Georgia right now refers to sovereign immunity, which is a little different. Qualified immunity falls under sovereign immunity categorically, but more broadly, what sovereign immunity is talking about is whether or not you can sue government agencies, the government itself, be that a local municipal government, county government, state government, or even the federal government, or the individual actors thereunder, the agents thereof. That's a trickier question because, well, a little bit. Because when you're talking about qualified immunity for police officers, you're talking about a mechanism that's intended to protect a police officer when he has to make split-second, life or death, in the moment, heat of combat decisions. And let me tell you something. If you've never been actively in combat returning fire against an armed and aggressive assailant, that's a thing that you will have a hard time legitimately understanding. You can try to wrap your head around it academically, but until you have been engaged in the time dilation that is black on ammo and actively returning, that's a conversation that you're ill-equipped to engage. When you talk about sovereign immunity, though, that's at a higher level, and that refers to that covers government employees, politicians, all that. And it argues that it's the intent of it is that if an elected official or a government agent makes a mistake and it causes harm to someone, that they made a mistake. Now, there are civil litigants that go in and win quite rightly, arguing that someone else bears responsibility for harm caused, for damage caused due to negligence, and that's perfectly reasonable. If you let the tree in your backyard get too dead and it falls over on the neighbor's house, then that's one thing. The Cameron just popped into the comments and he said it gets all spicy. It's not that spicy. It's just me and Alex arguing. We agree on a lot of stuff. But I think he and I have a different understanding of where qualified immunity occurs. So, but with the sovereign immunity, that's a little different. It's supposed to be the mechanism if you file suit against the government or against an agent of the government, where the judge can examine what happened. And I'm sorry, I don't have an example to hand easily right now, but the judge can examine what happened and say, look, this guy wasn't trying to hurt anybody. He thought he was doing the right thing. Maybe there was a complex study that said if we all wear masks and shut down the government to stop, I don't know, a pandemic from spreading more. And it won't cause dramatic poverty and starvation and increased suicide rates, right? And then you come back to it later and you say, oh, look, the numbers seem to say that it didn't actually make any difference in the rate of spread, and it did cause nearly irreparable harm to the economy and individual lives, with an increased rate of bankruptcies and suicides, drug use, spousal abuse, child abuse, divorces. I could go on. For sovereign immunity to protect the government actors in that case, the argument would have to be made and at least compelling, if not hard proved. And this is under the theory of sovereign immunity. That doesn't necessarily mean that that's under the application. That's an important distinction. But the judge could look at it and say, okay, look, they listened to the scientists, they followed the science, they did what was recommended by their advisors, and they had every reasonable expectation of a positive outcome from this activity and could not have foreseen the irreparable harm that people like Polytech and the Brushfire Mind tried and tried and tried for so long to tell people was clearly and obviously predictable. Maybe Obamacare is a good example for that one too. So that's kind of the nuts and bolts of sovereign immunity and qualified immunity, and the distinction being where the locus of the immunity lies, with the sovereign being the state at large and the agents thereof, which includes police. And that's why the part of sovereign immunity that covers the police is qualified immunity, because when you get to qualified immunity, the burden is supposed to be higher than the burden to prove sovereign immunity. The assumption there being that you have to prove that even if you can prove that the officer was acting in good faith, you can argue that someone's civil rights were violated. And when you start making the argument about whether or not someone's civil rights are violated in an interaction with the police, the context under which the police officer had to take a discretionary action and consider, he has to stand there and think to himself, am I violating this person's civil rights? And of course, the answer to that question, if you're wielding a knife and actively stabbing another police officer, the answer to that question when the other officer asks it is, oh, no, clearly not. You're stabbing my squad mate, and you have to die now. And keep in mind, as we were watching that, there were at least 2 officers with tasers dumping active voltage into that man as he stabbed that young lady repeatedly. But if you get rid of qualified immunity, those officers can be sued successfully. With qualified immunity, when that guy's mama goes to try and get rich off the state, a judge can say, no, woman, your boy stabbed a cop. It was okay to shoot him. That'll be $500 in court fees, and you can go away. You are dismissed. The abolition of qualified immunity means that the judge doesn't have that option. That's what qualified immunity is. And back to the ballot real quick. The limited information on the ballot, it's not just a question of whether or not you support the idea or oppose the idea of abolishing sovereign immunity and qualified immunity with, Sotomayor, the most racist justice in America, and Black Lives Matter, another racial supremacist organization. I'm sorry, Alex. These are the people who are calling for sovereign immunity. Who are calling to abolish qualified immunity, rather. It's not just the question of whether or not you stand with or against the terrorists on the issue. On the ballot, one item is listed. One. What else is in the bill? The headline on your bill that includes, for all I know, the headline could include the decriminalization of pedophilia. But that's not listed on the ballot. That's just included with the other thing that is maybe less objectionable. So no, I will always vote no on a resolution that appears on a ballot unless I've had some kind of extraordinary access to read the bill. You know, and it's one thing to say, oh, well, you could have gone and looked it up. Yes, that's the game we're going to play. The bills are all there where you can go and look them up. And that's what should be expected of citizens is we each of us go every day and we search through the archives, we search through the publications, we search through the everything and read all the laws and bills. If I had my way, you would never, ever be able to submit a bill for a vote that included more than one action item or spanned more than one page. Period. No more than one action item, no more than one page. You want to write a bill that that sends a check for $1,200 to every American? That bill says, we decided to send $1,200 to every American. Sign here. And that's the end of it. It does not go on to say that we're going to mandate all mail-in, national mandated mail-in ballots, and we're going to demand that the airlines reduce their carbon footprint to zero within 50 years, and we're going to demand that a government board be established to determine the tolerable distribution of ethnicity and sexual preference on corporate boards, and we're going to. No. One item, one page. If you can't do that, you're a criminal. Because you are not faithfully serving your oath. And to be clear on my understanding and the way that I'm using that language when I talk about someone being unable to faithfully serve the oath, you take an oath of office. The oath of office that you take when you become the president, a senator, a justice, is very similar to the oath that you take when you become a soldier. It differs at the end because we also swear to follow and obey the orders of those officers appointed above us. But the rest of it is broadly the same. It's almost identical in the language, primarily and principally in the I swear to uphold and defend the Constitution of the United States of America. Not the country, not the United States of America, not the government, not the land, not the people, not its elected officials. The Constitution. I swear to uphold and defend the Constitution. So, understanding that, understand this. Violating your oath can be grounds for Uniform Code of Military Justice, Article 15, non-judicial punishment, including, up to and including, the loss of half your pay for a period of 90 days, extra duty, which means that everybody else gets off work at 1700 and you keep working till 10 or midnight. And that's usually frivolous, painful, intentionally difficult work that's meant to punish you for having done what you did. Restricted liberties can go a long way. And then outlaw the omnibus. Here, Steve. I think I lost Alex. I hope I didn't piss him off and drive him away, but he stopped commenting. Anyway, that UCMJ can hit you with the Article 15 and punish you severely. Or, depending on how you violate the oath, for having violated the oath, not any other particular action necessarily, you can be dismissed. You can be dishonorably discharged from the Army, or the Marine Corps, or the Navy, or the Air Force, or what's that other one that pretends to be a service? Anyway, and to be dishonorably discharged from the military is almost identical to being a convicted felon. In the way that it alters your rights and reflects on your ability to get a job. It is not a small thing that one just hand waves away. So, all right, that's my show this morning. I hope you guys enjoyed it. Alex, if you're still watching, thanks for Thanks for getting in and butting heads with me. It always makes it more interesting. And love you guys, and we'll see you tomorrow morning. I'll try to be up on time, but y'all, things have been weird lately. It is what it is. I'll see you when I see you. But it'll be in the morning.